believes that the mortgage does not accurately reflect the intent of the parties.
Well, that mortgage legal description is barely off, and it has a tax parcel number and an address that would clearly identify this property. So I have a hard time following your argument. I'll just be honest with you up front.
And I appreciate the chance to attack that up front, because the issue here is what the bank has called in the trial court and before this court, labeled a so-called single-digit error, is actually material or potentially material. We don't know because there was no surveyor's evidence presented. And here's why. A single-digit error can be material. So, for example, imagine.
The case law addresses that issue as far as when there is a property address on the mortgage and the error in the description appears to be relatively minor, doesn't it?
Well, the cases that the bank relies on are cases where there's an error, where there's something omitted so that there's no conflict in the document. What we've discovered here is that there's a conflict. There's a parcel description and a property address, and then there's a legal description which is admittedly wrong, judicially admitted to be wrong. And if you look at the legal description, it is in the second segment of the property description. So what we have is we have a boundary that you started at an origin point, you go one segment. It is the second segment that is wrong, which means that the starting point for the next segment is wrong, which means that the starting point for the final segment is wrong. So we don't know the degree to which the error was significant because there was no evidence in the trial court of that fact.
Your client was misled in defending this case because of that error?
Well, it's because the issue was that the mortgage, the question is whether a mortgage that has an error, whose significance is unknown, can suffice to support a foreclosure when the reformation count, which by the way was argued all the way through summary judgment, when the reformation count is mooted by the trial court without notice to the parties. So we don't know what that mortgage actually encumbers. So, again, the single digit issue could be significant because
Your client was living at the property with that address that was in the mortgage, is that correct?
that's correct, Your Honor.
And your client had paid some payments on the mortgage that was on that property described with that property address?
That's correct.
And there was notice of default that was sent to that property address where your client was living?
That was not an issue in the trial court.
I just
So
want to make sure factually I had a full understanding of what your client's role on this piece of property that was described in the mortgage with a property address.
we know where the street address was. We don't know what the boundaries that were described here. So going back to the example I was about to raise is that if my calendar said that today's oral argument was on November 3rd, and I showed up tomorrow instead of today, that would be a single digit error that's material.
Well, it's not the same thing, but I understand your point.
Well, and the reason that this is an issue, the reason why the case law has that the standard is whether a surveyor can accurately locate the land is because when you have boundaries that slop over onto or slop inward on neighbors' properties, it affects title for all the properties as well. That's why it's important to have an accurate.
This is in the middle of the legal, and the trial court in the first footnote found that the description adequately described the property such that the entirety of the property identified in the deed is encumbered by the mortgage. And that's not inconsistent with the case law that talks about you don't even have to have a meets and bounds description if you've got a property address or folio number.
And number one, the trial court made that finding without any evidence of that fact. For example, the standard is whether a surveyor could accurately locate it. In the Cope case that the bank relies on, there was an affidavit from the surveyor.
Right.
And the case law,
but the surveyor isn't the be all and end all here. It's a more generalized question of could the property be identified, and address has been conventionally accepted as a way to do that.
it is in the absence of conflicting information. And what this case has differently from all other cases is that there's two things. Number one is there's a judicial admission that it's not correct. It's an admission that it's not accurate. We don't know the degree
There's
to
no
which.
dispute that there was an error in the meets and bounds description. That's a given fact, right?
That's the record before us. That's judicially admitted by the plaintiff.
Nobody's disputed that there is a numerical problem in one number in the meets and bounds description. But the case law also talks about, as I've said, and Judge LaBridge has now reiterated, that if you have a property address and there doesn't, at least in my mind, there doesn't appear to be a significant deviation in the meets and bounds. There appears to be a problem, but nobody seems to be fooled as to where this property was. I'm not quite sure I understand why the court couldn't conclude, you don't need reformation for this because we have an adequate description that nobody's misled by.
The cases that describe the property address as sufficient almost universally involve where there's a property address and a parcel number, but no conflicting information in the mortgage or the deed.
I understand. Your
Okay, and so the conflict here is where we get, and the significance of the error is at this point unknown. We don't know the effect of the description of the legal, because there was no evidence before the trial court.
We don't know the effect on other property owners, or we don't know the effect on your client.
Both.
Well, again, I go back to your client lived at that property address.
Yes, you did.
Paid the mortgage payments up to a certain point on that property address. Nobody kicked them out saying you're living at the wrong property. So what is the impact on your client? What's the harmful error as to your client?
The property that was foreclosed, while we can look to the legal description, we can look to the parcel description and the
Was the
address.
property foreclosed at that property address, the street address that's listed in the mortgage?
The address was foreclosed, correct, but we don't know, because of the way the mortgage was done, what is encumbered in that foreclosed property. We don't know, does Ms. Slovak retain portions of the original property? Has the foreclosure affected title for the neighbors, where pieces of their property been removed?
This sounds
Homestead.
very interesting in a quiet title case, but against the backdrop of these cases that establish property address sufficient to locate, et cetera, it seems like we're, for lack of a better term, kind of splitting hairs with what boils down to a minor discrepancy in the legal on the mortgage, which after the foreclosure judgment deed is recorded, could, certainly create a bonanza for a title examiner, but not from the foreclosing.
And that's why it's so important to get it right. Florida homestead is actually one of the most protected property interests in perhaps the country. And if you're going to take someone's home, is it too much to ask that we actually do it correctly? I don't believe it is. And that's what we're asking to be done here. Because where we have this admitted discrepancy, where we have this actual conflict that exists inside the mortgage itself that was undiscovered until it was raised by the bank. So the Mitchell case, for example, would probably label that as a latent issue.
Does the description limit or expand the?
We don't know, because there was no evidence. That's the problem.
Well, the harm, if any, to anyone would be to adjacent landowners who this incorrect legal description might actually overlap onto their property. But it would seem to me that the tax parcel number, it absolutely, that provides tremendous information. And you go to the property appraiser's site with a tax parcel number, it'll show a diagram of the property and it'll give a limited legal description. The address is important, but the tax parcel number basically is almost a fix-all. It shows everything.
And the problem comes in where we have the conflict, because we're at summary judgment in particular, where you have two conflicting pieces of evidence. The trial judge was not free to enter summary judgment on that issue. Now, if this were a trial situation, we would be in a much different posture. But where there is that latent ambiguity.
But now you agree that we're applying the new standard here,
Yes.
and just conjuring up the possibility of what amounts to a paper issue may not ever have been, but certainly is not now sufficient to withstand summary judgment. And again, this discrepancy, to my way of thinking, is a problem potentially for the purchaser at the foreclosure sale and whatever title underwriting is out there. But from the perspective of, could the bank foreclose on the basis of the address and the parcel ID number, folio number? Help me out with how the trial court erred legally.
Yes. It's our position that under the new standard, that the trial court was even less free to depart from judicial admissions where it says the mortgage document is incorrect.
But
This is
you're
not
talking
your
about
paper issue.
the allegations in support of the Reformation claim. When you say judicial admissions.
That's exactly what I'm referring to, yes, where the plaintiff judicially admitted that the document did not reflect accurately the intent of the parties. And so your point to the future purchaser When the state is involved in removing homestead property from one person and where the clerk of court auctions it off to the next person, I know we have a buyer beware standard for foreclosures, but where the state is participating and foisting off a title problem on someone else, at summary judgment, shouldn't we make sure at least that there's some accuracy there? Shouldn't we make sure that is done right? And also too, was the trial court free, even under the new standard, which changed during the process of the case, and from the motion to the final hearing, the standard was changed in the interim, and the trial court recognized that. But where we have that, was the trial court free to simply disregard the evidence presented by the bank and that it was not accurately reflected? Was it free to disregard that, and was it free to move the reformation count?
Well, but the court was faced with a foreclosure case, and the court was determined, has the bank made a case for foreclosure? They weren't there to solve the quiet title action. It would have been neater and tidier if the reformation action would have solved the issue. But that really wasn't that wasn't what the court was required to do. The court was determined, should this mortgage be foreclosed, and is this property sufficiently described to be able to do that? Yes, there'll be some title cleanup and another action down the road. It's probably not the best use of judicial economy, but that wasn't what the court was faced with. The question was this motion for summary judgment to foreclose on this property. Is summary judgment proper at this point? And the court had enough before it to make that decision.
Well, and the trial court was faced with the reformation claim and disregarded it. Didn't overlook it, didn't disregard it, but simply stepped around it. And
it might not have been what I would do if I were sitting there, but it was certainly within the parameters of the options the court had. The court was basically trying to resolve the summary judgment in front of it. And it appears that it was appropriate for it to do that. Yes, this issue remained unsolved. It's still out there. It actually can be fixed by a corrective deed even, doesn't even need a quiet title action. So
the issue here is that it's our position that the foreclosure, where there is a reformation count, where there is an admitted discrepancy of the materiality of which we are not aware, because there is no evidence in summary judgment, would preclude.
Well, one of the things the
That's
trial
summary
court
judgment.
said that I think does go to materiality is in the order, the trial court analyzes the meets and bounds description to say that the address is identical, there is, that you can find the same point of beginning, the same first boundary, the third and final boundary. Nothing about these descriptions would cause a surveyor to doubt that he or she has located the encumbered property. Isn't that a determination that this discrepancy is not material?
One that I believe is without sufficient supporting evidence, because again, the issue here is that it's not merely the start point and the end point. It's also the meets and bounds describe the actual boundaries of the property. And if those boundaries conflict with,
has a ripple effect.
it does. And so to the extent that the trial court found, whether it was a conclusion of law or conclusion of fact, the factual part of it, we believe, is not, at least at summary judgment, sufficient to support the judgment. And the conclusion of law without that factual basis is an error. And so we would ask that this court reverse the summary judgment and remand for further proceedings, which is the appropriate remedy for this type of confusing and unfortunately, jumbled case where we have a mortgage that doesn't match internally to what is supposed to be foreclosed.
Thank you. You'll have 5 minutes, sir, when we return.
Good morning, may it please the court, Charles Secker here on behalf of Deutsche Bank. I think that this panel has identified the singular issue here, whether or not this 5-digit, singular digit directional error were material enough to preclude the entry of summary judgment. We have a well-reasoned final judgment of foreclosure, and the trial court went through each step and analyzed exactly why it found our mortgage sufficiently described the property, absent the minor 5-digit single directional error in the property description. But we don't even have to just rely on the mortgage itself, because the trial court was presented with ample cumulative evidence outside of the mortgage, and the trial court noted that in its final judgment. The trial court looked at the property address was included in the note, which matched the property address.
Did the trial court have before it, but I don't think it did, the legal description as plotted?
It's plotted, yeah, yes, it had
As
it.
plotted, so it shows how the discrepancy would play out. So my question is, at the summary judgment hearing, was that part of the submittal?
That wasn't part of our submittal, but
Was.
in the final judgment, the court noted that this was a planned community. So that was one of the factors it looked at to determine that there was no question that the mortgage sufficiently described the property absent that minor error. But we also introduced the certified copy of the property appraiser website report that had the correct legal description. We had a certified copy of the deed that had the correct legal description. We had the address that was on the note, and as you correctly pointed out, there was the parcel ID taken from the property appraiser's website. So we have a mountain of evidence indicating that the 5-digit directional error included in the legal description of the mortgage. You could easily identify this property even in the face of that. I don't think that at the end of the day, that small error would rise to the level of what the court would be precluded in entering summary judgment. And I'd like to point out that.
So let me ask you a question. If the error were much more egregious, and you still have the property address and the tax parcel number, would the court be correct in granting summary judgment?
Yeah, yes, sir, I believe so, because the court was looking for outside evidence to determine whether or not the property was properly identified in the mortgage, and that outside evidence, the property appraiser's website, information of the warranty deed, and even the address of the parcel ID, that all.
So then are you saying that the legal description on a mortgage and a foreclosure action is largely irrelevant as long as there's a property address and a tax parcel number?
I'm not saying that, but I'm saying, I guess it would be a case-by-case determination, and in this case, you can see we've got a minor error. I don't know how much larger an error will be required before the trial court can't make the determination based on extraneous evidence that the property description is properly described in the mortgage. I think, but we can kind of, we have instruction from this court in the Cope decision, which we cited in our brief. In the Cope decision, this court looked at the property address itself that was included in the mortgage and determined that the mortgage sufficiently uncovered the property. In the Cope decision, this court did note that there was an affidavit from a surveyor, but as this panel has identified, the surveyor's affidavit is not the standard. In Cope cases, the court noted we've got precedent and an affidavit from a surveyor. We don't have an affidavit from a surveyor, but we don't need that. We have plenty of evidence demonstrating that this mortgage was properly identified. The property was properly identified in this mortgage. And I think this goes to this new standard, which was touched on, that metaphysical doubt is no longer enough. And that's what Solex counsel is arguing, that there's some metaphysical doubt that we don't know where this property really lies. But metaphysical doubt is no longer the standard. At this point, the Supreme Court has stated that the inquiry in summary judgment is whether the evidence presents a sufficient disagreement to require submission to a jury, or whether it's so one-sided that one party must prevail as a matter of law. And we have that, Your Honors. We've met that one-sided. We've got the mortgage, we've got the note, we've got the parcel ID, we've got the property appraiser's website printout, we've got the certified warranty deed, we've got a property that's in a planned community. This error that's included in the legal description, even in the face of that error, this property needs to be identified, and it was so identified by the trial court. So to sustain its decision to dismiss the reformation action and find the final summary judgment foreclosure is appropriate. If there's no further questions.
Thank you very much. You have 5 minutes, sir.
Thank you, Your Honor. One thing I'd like to point out in its final judgment, after marching through its conclusions of law and findings of fact and summary judgment, when it entered the foreclosure judgment itself, the form approved by the Florida Supreme Court, it entered a foreclosure judgment on the corrected legal description. It actually did reform the mortgage, even as it dismissed the reformation claim. So clearly, the trial court thought that that legal description was material, otherwise it would not have done that. And so what we have here is, this is not a metaphysical doubt. This is not a hypothetical or a paper issue. This is a matter where the evidence at summary judgment is, on the one hand, this is the parcel ID number. On the other hand, this is a legal description that is admittedly incorrect. And
Equipped with the property appraiser folio number and the street address and the record in this case, is there a view of the trial court's, of the legal that the trial court put in the foreclosure judgment, that that's simply a clerical correction akin to, 1.530A type correction?
well, Your Honor, this was not a 1.530 where a court.
I get it. I'm using that by analogy.
Very
Scrivener's error.
So then what legal description should the trial court have used? Should it have used the one on the mortgage? Should it have omitted the legal description from the final judgment and just used the property address? Or should it have used the corrected, reformed legal description that the bank was seeking? Which is the right answer? I don't know the answer to that question, but it is clear to me at least that on summary judgment where the trial court says, I'm not going to grant your reformation count because I think it's not material, but then actually does, I think that.
Did you argue this in your brief?
The record shows that the legal description has been corrected. It's on the record. So as far as briefing the issue of whether the trial judge did that or not, we did argue that it didn't have the wherewithal to dismiss without notice the reformation count, and I think this fits in that box. Counsel referenced the Cope case, and I want to address that as well. The difference between Cope and this case is that the surveyor's affidavit supported a conclusion that those errors did not render the deed unambiguous. Let me rephrase, that the mortgage in Cope was not ambiguous, because what we have there was a lot number and then merely a legal description or a parcel number. They had omitted the lot number from the third lot. It was an omission, not a conflict. And so that's why Cope actually supports the idea that when there's conflicting data within the mortgage, that raises a problem. And to answer Judge Silverman, or Judge Morris, rather, your question, was there a plot? Which I'm assuming you're asking for, was there a graphic depiction of the property?
Yeah, I'm pretty sure there wasn't, but I'm wondering why there wasn't.
So am I. The closest thing that we saw was the certified copy of the property appraiser's website, which did have a not to scale rendition of the structure of the property. So that would not be an illustration of the meets and bounds of the difference between them. And so that is something that, again, something a surveyor could have provided, something that
Well, any real estate lawyer can plot a legal description.
perhaps, I'm a litigator rather than a real estate lawyer. So.
Yeah, I mean, I know it's a dying art because computers now do this, but most real estate lawyers have a computer software program that will plot a legal description.
And so to the bank's point as well, that there was an issue with regard to the evidence provided to the court. The evidence of the property address and the portfolio number and the folio number, all those things. Well, there was evidence that those things matched, but there also was evidence there that the property address, the legal description that was in the property appraiser's records conflicted with the mortgage. And so at that point, then, could the trial court look at that evidence and say reformation is good? Because we don't know, again, the significance of the legal error right here. So unless there's any other questions, I'm just going to rest on my briefs and request that the court reverse and remand further
Your
proceedings.
timing is impeccable.
Thanks, Your Honor.
You did a great job, both of you. We appreciate your efforts. It's helpful to us in resolving this case. Have a good day. Case Town of Reddington Beach versus